certainly I suggest that Mr. Vance's complaints about the state of free speech in the UK are ridiculous and ill-informed, and his parallel suggestion that democracy is in retreat are not much better. There are challenges to both free speech and democracy. Indeed, my book is largely about them. But I think that these are complicated issues which are not assisted by ill-informed rants from the likes of the Vice President of the United States.
Jonathan Sumption is a renowned academic, revered historian, esteemed lawyer, and one of Britain's greatest public intellectuals. As an historian, he's the writer of a prize-winning 5-volume history of the 100 Years' War. And as a British judge, he served on the Supreme Court from 2012 to 2018, where he cemented his reputation as a considerable intellectual force. He's written many books, including Trials of State, Law in the Time of Crisis, and his latest work, The Challenges of Democracy and the Rule of Law. So Jonathan Sumption, thank you very much for joining me today.
Happy to be here.
Tell me, the challenges of democracy, is that rather than challenges to democracy, was that a deliberate choice of yours in terms of the title?
Either version of the title would do just as well.
Fine, okay. And you identify within this book 3 principal enemies of democracy, particularly in your very first essay in here. The first is economic instability. The second is fear within the population that might make them run towards security, and also a growing intolerance and a polarization within society. Which of those 3 would you say you're most worried about?
Well, I change my view on that depending on what's currently happening. Clearly, if one put oneself back to the position 5 years ago when the government started to lock people down because of COVID, then one would identify fear. If, on the other hand, you're looking at the period of time when Just Stop Oil and Extinction Rebellion were blocking the streets, one would say moral and political intolerance. As for economic insecurity, that has been with us for quite some time.
The Policy Exchange wants to add another one to this list. And they've argued that, from their point of view, judges threaten the rule of law and effective economic government. They have concerns about the use of judicial review and the Human Rights Act. Do you think that activist judges are a serious problem and maybe even a threat to democracy itself, or not?
They're a less serious problem now than they were when I delivered my Wreath lectures on precisely this theme in 2019, because I think that a new generation of judges is beginning to look again at the foundations of what one might call the great activist period, which probably began around 2000 and continued for some 2 decades. There have been a number of decisions of the Supreme Court since I left, which indicate, I think, a rather healthy tendency to eschew interference with policy on the basis that policy is primarily a matter for Parliament and for what inferences can be drawn from parliamentary legislation. We are a democracy because ministers are responsible to Parliament. We wouldn't be otherwise. But I certainly think that you have to be quite careful about what you accuse the judges of doing. It is absolutely right that judges should keep ministers within the powers that Parliament has entrusted to them. So it's perfectly legitimate for the courts to say that ministers do not have the power at all to do something that they have done, or that they did not have power to do it for the particular purpose for which they were trying to do it. There is a tendency, I think, for ministers to take a power intended for one purpose and use it for a quite different one. All of these are measures that are designed to reinforce the power of Parliament and to reinforce the limits that Parliament has placed, actually or implicitly, on what ministers do. That's one area which it seems to me is entirely legitimate area for judicial intervention. I think activism is a misleading term. On the other hand, there are areas where the minister undoubtedly has got power to do the thing, and indeed it lies within the broad purpose of the power. But grounds that they think that the policy underlying it is irrational, or more frequently, that it is contrary to the jurisprudence developed by the Strasbourg Court on the Human Rights Act. That seems to me to be a lot more questionable, because that is not defending the right of Parliament to confer powers and to limit those powers. It is essentially intervening in the way that those powers are used. I think that it is inevitable in the current state of the law that the courts are going to enforce the Human Rights Convention, because that's what they're required to do by the Human Rights Act of 1998. Whether that is a good thing is another question altogether.
Yes. There's been an interesting development, I think, this week, in fact, where a judge was particularly spoken of in Parliament. I think it was that this situation where 6 family members from Gaza were admitted into the country on rules which were specifically aimed at Ukrainians. Would you call that judicial overreach, or is that a legitimate use of the judge's powers?
Well, I haven't studied the judgment, and so I am not prepared to express a firm view about that.
Enough.
My understanding is, but this isn't based on a study of the judgment, that the judgment was not in fact based on a series of rules devised for Ukraine, although there had been at one stage an attempt to base it on that, or what seems to have been an attempt to base it on that. But, I would need to study the judgment a lot more carefully before expressing any view at all. What I do think was rather surprising was that the Chief Justice chose to rebuke both the leader of the opposition and the Prime Minister for saying that they thought that the result was unacceptable, or, to use the Prime Minister's words, wrong. I think there is an important convention which ought to be observed by politicians, that you do not abuse judges, you do not threaten them, but I do not see why judges should not be as much open to criticism as any other decision maker in the public realm. It seems to me that temperate criticism to the effect that the judge got something wrong is perfectly legitimate. It's the sort of thing that you would read in a legal journal every day of the week. If you were to open it at a random page, you would find criticism of judicial decisions. Why politicians should be the only class of people who are not allowed to regret that judges decided something in the way that they did is something beyond me. So I think that this particular intervention by the Lord Chief Justice was unfortunate.
Looking at the whole picture of the relationship between the judiciary and the legislature, how do you know when the balance between the judiciary and Parliament is running out of kilter? Is there a test for that?
Well, there isn't a simple test, because it's far too dependent on the context and the particular case. But I think that the dichotomy which I mentioned a few minutes ago between cases where the minister did not have power to do things at all, or for the purpose for which he sought to do it, and cases where there is an intervention in policy, is a good starting point.
Can we move on to talk about human rights, because you deal with human rights quite a little bit, fair bit in your book here, and in particular, you try to identify the fundamental human rights, which you put into two categories. So you've identified the kind of internal rights, freedom of thought, freedom of expression, those rights which we have, which make us human beings, or give us the faculty of acting as human beings. And the second one is, I suppose I could call these the external kind of rights of freedom of association and freedom of assembly, which then allow you to participate in the democratic process.
Yes, I mean, I think the essay which you're referring to is one in which I sought to suggest that asking whether something is a human right or not may not be the right approach. The object of human rights law is to entrench certain rights, to put them beyond the reach of political choice by conferring the power to deal with them exclusively on legal bodies like the Strasbourg Court of Human Rights. I think that what you have to do is ask yourself, what are the rights that it is important to entrench? There are many things which you can loosely describe as human rights, which a civilized legislature should want to enact if they're not already part of the law. But that doesn't necessarily mean that they should be beyond the scope of a future legislature to revise or indeed even to abrogate. I think you have to start by saying what rights should be beyond the reach of politics and legislation. And I identified two classes. There are those rights without which we really can't be a society at all. For example, a right to be protected against arbitrary violence, fraud, and so on. The rights without which society simply becomes a contest in the deployment of crude force. And those are obviously the rights to life, liberty, and so on, without proper cause. Now, the other category are rights without which you can't be a democracy. I don't think that democracy itself is a human right. We had perfectly civilized laws before we were ever a democracy. I think that democracy is a superior form of government, but that is a rather different point. However, the fact is we are a democracy. We want to remain one. I think at least most of us do. And to be a democracy, there have to be some further rights. They're the ones that you mentioned: freedom of speech, freedom of thought, freedom of association, and so on. And of course, a right to participate in fairly held elections at reasonable intervals. Now, that leaves aside a number of rights which don't fall into either category. For example, a right to privacy, and so on. I would say that about those that they are very desirable rights, but they are not rights which it is either necessary or desirable to entrench, not least because sometimes they may have to yield to other public interests, like, for example, the detection and suppression of crime. And I would not wish to entrench those, nor would I wish to confer the adjudication of those rights and their limits on a judicial body. Certainly, whatever rights exist need to be enforced by the courts. But if you're deciding, for example, how much privacy you're prepared to sacrifice in the interests of public order or the detection and punishment of crime, that seems to me to be fundamentally a political question on which human beings in a society will disagree among themselves, and the correct method of resolving that disagreement is some kind of political process. in a democracy that will normally involve legislation. But it's not a matter for the courts.
When you talk about entrenching these rights, what do you have in mind? How are they entrenched as such? How are they given a superior status? I mean, are you arguing for something equivalent to the American Constitution, where you have a First Amendment right, of which that stands above the courts and indeed the legislature, unless the legislature has a supermajority, of course, when it can change it. But an ordinary majority can't change it. Is that how you entrench rights?
I'm not arguing for that. And in the British constitutional settlement, which I think is a very useful compromise between a number of different considerations, it's not possible to entrench rights. No parliament can be prevented by its predecessors from amending or abrogating any particular rights. The most that you can do in the UK Constitution is to institute a tripwire which will make it more difficult, politically more difficult, to alter certain rights. And that is exactly what we have done in passing the Human Rights Act. The Human Rights Act can be amended. Particular rights can be overridden by legislation. In some circumstances, it can be overridden by other inconsistent public interests. Now, none of these rights, therefore, are not wholly entrenched, but they are partly entrenched. That's to say that they are more difficult to repeal than other ordinary legislation. It would not be difficult to repeal the Dangerous Dogs Act. It would be very much more difficult politically to repeal the Human Rights Act. So you can have a partial measure of entrenchment, which is as much as can be achieved under the British constitutional settlement. Other countries have entrenched rights which are absolutely entrenched. The United States is a good example, although we are witnessing the spectacle of much of those being undone in the United States by rather indirect means. But you know, there is an argument for which we often hear that we need a written constitution, which would presumably absolutely entrench these rights. I would be against that.
There's a fundamental question which is really underneath all of this, which really we've not asked, and that is, where do these fundamental rights come from? Are they dispensed by divine right or by human nature, or are they dispensed by the state so that they are given by the state and can be taken by the state?
Well, I think the standard answer that would be given by human rights enthusiasts to that question is to say that there are some rights which are inherent in our humanity. I find that very difficult to accept because it seems to me that humanity is not a uniform commodity like grains of rice or wood chips. Humanity lives in societies whose instincts are very sensitive to their history and their culture. And I don't therefore accept that there are rights which belong universally to mankind simply because they are human beings. It seems to me that rights are a creation of social organisms, and one can have as many or as few of them as one likes, even if one has a written constitution on the American or, say, the French model. Those constitutions are themselves made by human beings in what they suppose, either rightly or wrongly, to be their long-term interest. They are artificial but valuable creations of human societies. They're not inherent in humanity.
So are there such things as inalienable rights, rights which cannot be taken away? And the rights which you've mentioned of free speech, free expression, are those special rights, are they inalienable or not?
No rights are inalienable because whatever is created by human institutions can be abolished or amended by human institutions. There are, however, rights without which life is either intolerable or social life is impossible. I've cited protection against arbitrary infringements of life or liberty as among the rights without which you cannot be a social organism. Now, I don't suppose anybody in their right mind would say, well, we don't need societies at all. But clearly, if somebody were to say that, then these rights would have to be revoked. I think that would be absurd. So there are rights which are fundamental. That does not mean that they are inalienable. Indeed, there have been countries that have imploded and violated systematically all of those basic rights without which you really can't be a society at all. And the result has been a wretched chaos which nobody would want to live in.
I know, for example, you have been quite a vocal critic of lockdown, and
Yes,
that was the taking away of the rights of free assembly for a substantial period of time.
yes.
How do you how do you argue then against lockdown if you don't go along with inalienable rights if they can be removed?
What you can say is that this is an attack on, lockdowns were an attack on a fundamental feature of human personality and human societies, namely the association between human beings. I would not say that there are no circumstances in which that is legitimate, but I did not think that COVID-19 was a sufficiently serious crisis to justify such an extreme measure. Now, uh, I avoid the use of the word inalienable because I don't think that the right to associate with other human beings is inalienable either. What I think about it is that it is a right of exceptional importance, which should only be infringed in the most extreme circumstances, of which COVID-19 was not one.
You quote the infamous statement, I would say infamous, by Professor Ferguson,
Mhm.
who explained what had changed in order to allow lockdown to occur. And he said it's a in the Chinese example was that it was a communist one-party state. We said we couldn't get away with it in Europe, we thought, and then Italy did it, and then we realized we could. You say it's worth pausing to reflect on what that means. It means that because a lockdown of the entire population appeared to work in a country which was notoriously indifferent to individual rights and traditionally treats human beings as mere instruments of state policy, they could get away with doing the same thing in Britain. And
Yes, well, that encapsulates my view. I
yeah.
thought that their initial instinct was clearly right. We couldn't get away with it here. And that what we witnessed during the COVID pandemic was essentially a breakdown of some fundamental assumptions underlying the way in which human societies work, certainly in the West.
Okay. You were very, say, strong and still are very strong on arguments against lockdown. But
Mhm.
a number of people were quite disappointed when you came out in favor of vaccine passports, which are maybe a minor form of an infringement of free assembly, taking part in society. Do you still hold that same view on reflection?
Well, I think that you are quoting only part of what I said.
Sorry.
I think it was highly regrettable that passports should be necessary. At the time when the question of vaccine passports arose, the government was determined to persist in its policy of lockdowns. It seemed to me that if you had to have lockdowns, and I thought that lockdowns were a very serious mistake, but if you had to have them, then the more let-outs that you got for people who were not seriously at risk either themselves or of transmitting it to other people, if you had to have lockdowns, then any let out from that was more desirable than nothing. Of course, I would very much have preferred that the problem had not been created by the government's own decision to have the lockdowns in the first place.
Did it make any difference to your opinion on subsequently finding out that the vaccination was not a sterilizing vaccination, that it didn't stop transmission of the virus?
Well, my understanding is that it didn't always do so, but that it usually did.
Yeah, in this case, I don't think it did, from my knowledge of it. Can I, just before we move on to the next area, talking about rights of assembly in order to take part in the democratic process, do you believe that prisoners should still have the right to vote, or should that be removed from
them? I personally think that there is no justification for depriving prisoners of the right to vote. But I accept the right of a society through its legislation to deprive them of it.
That doesn't cause any conflict with fundamental rights?
I don't believe so, no. I think that it's an optional question whether you regard the commission of crimes serious enough to warrant imprisonment as also justifying the withdrawal of some of your democratic rights. I think that there's a perfectly sensible argument, though I don't accept it, in favor of depriving them of their democratic rights. Personally, I think that the advantage of giving prisoners the vote is that it gives them some degree of participation in the society whose norms they have offended, and is therefore a small step, a very small step, in favor of their reintegration in that society when they are eventually released.
The West suffers a particular problem with illegal migration, and it's a problem which governments have been unable to solve. I mean, for 14 years, the Conservative government, each time it went up for re-election, promised to solve this particular problem of illegal migration. The present government has also made a similar promise, but they seem to have been unable to solve the difficulty. Now, my point about it in terms of democracy is, does this not impact strongly the feeling that we can have no confidence in our system because the government itself does not have the power to do what it claims it will do for the electorate? And therefore, I think you quote somewhere like 42% of people of the electorate would prefer a strong man to come in and deal with issues, possibly because they see the democratic system as not functioning.
Well, immigration is a complicated problem, and it is a problem in which governments have not been entirely honest, and people have not been willing to analyze the problem in sufficient depth. Illegal migration is quite a small proportion of the overall level of migration. Legal migration is on a much, much larger scale. The figures change from time to time, but the major source of migration is not illegal migration. It's not boat people. It's people who get visas. And the reason why they get visas is that governments grant visas so that, for example, care homes can be properly staffed. They're overwhelmingly staffed by people who have arrived here as legal migrants. And the alternative would be to pay care workers a great deal more so that people would be prepared to take the job who are already in this country. Now, governments are not prepared to do that because the cost of care of old age care in a high proportion of cases ultimately falls on the exchequer. So that is what I mean when I refer to the dishonesty of governments. They basically pretend that this is mainly about illegal migration when it isn't. And they pretend that there's something that they can do about it when in fact they're not doing that. they are issuing the visas which legal migrants are using to get into this country. Now, I'm not objecting to that. I'm simply pointing out that there is a fundamental irrationality, not only at government level, but also at the level of the public, because the public, I think, have a number of inconsistent views. They object to high levels of migration. But when you bring them down to individual cases or to individual categories, they're not so sure. People are not willing to have care homes collapse, and they may not be willing to suffer the tax increases that might enable the people who work in care homes to be paid more. So people have ambivalent views about this.
Yes, but I think the point I'm trying to get at is does this not bring democracy as a system into a kind of a disrepute or a feeling that there is no point in electing any government, because although they may promise various things, they seem to be either unable to do it because they lack the power, or as you were suggesting, they may be dishonest about what they claim.
Yes, of course it does. It undermines trust, and that undermines faith in democracy and people's willingness to go along with it. I mean, I certainly don't wish to suggest that immigration is the sole factor at work. There are a variety of other issues which give rise to much the same problem. But you're absolutely right that distrust in politicians is a serious problem for democracy. And some of that distrust is unjustified, but some of it is justified. And we've just been talking about an area where the distrust is justified. Ultimately, we have a dilemma when it comes to immigration. We need migrants in many sectors of our economy, but we don't want them. And that is a dilemma which I think it would be helpful if governments were a lot more honest about. If the electorate then insisted that on having on electing parties which want to bring an end to migration full stop, they would be doing that at least with some understanding of what the economic consequences would be.
Is there similarly, besides a distrust in politicians, is there similarly a distrust in the judiciary at the present time due to the fact, distrust is the wrong word, I think, but lack of confidence maybe, insofar as there have been a continuous stream of cases which have recently been adjudicated in allowing people who have very light reasons for staying in the country allowed to come in.
There is a very, very large volume of cases going through immigration tribunals and has been for a number of years. The number of cases that give rise to these rows is actually quite small as a proportion of the whole. Even in relation to those cases, they are not always correctly reported in the press, which can be very selective in identifying the reasons which the judge gave for his decision. One often finds, when actually reading the judgment, that it's based on an altogether broader and more rational set of considerations than those which you have just cited. Now, I think one should therefore be wary about reading press criticism as if it reflected a general dissatisfaction with judges. There are many judges in this country. They have a very large caseload, and inevitably, some of them will make mistakes. We have courts of appeal whose job it is to deal with that. Sometimes the government does not appeal, and it may or may not be right to take that line. So I think it's a nuanced position. Looking at the matter altogether more broadly and getting away from particular rows about, for example, immigration or sentencing, which are the two areas that most often give rise to criticisms of the judges, I think that the collective reputation of the judiciary in this country, and particularly the senior judiciary, by which I mean High Court and above, is pretty high. On the whole, I think there's a very high level of trust in judges, which in my view is wholly deserved.
The last section of your book deals with free speech.
Yes.
And there are some pertinent issues which have occurred quite recently, which have impacted upon questions about free speech in our own country and maybe the danger which that's under. Only last week, I think it was, the Vice President of the United States of America gave a talk in Munich, and he actually cited some cases in this country. He said that he thought that the main threat to democracy did not come from Russia or from China, but came from within, to quote him. And he claimed that EU countries and the UK especially has retreated from its core values. Do you share Vance's fears that this undermines democratic principles?
No, I don't. I think you have to distinguish between two distinct threats to freedom of speech. One is government legislation, and an example of that is the legislation which exists in both England and Scotland, which creates safe zones around abortion clinics, a subject which Mr. Vance seems to be particularly exercised about. The other is the threat that comes from the pressure to conform from public opinion or sectors of public opinion, noisy people behind the campaigns to cancel certain expressions of opinion. Now, the latter is not a governmental decision, and indeed the courts have been pretty diligent in enforcing people's rights not to be troubled by that. But ultimately, law and political decision-making can't deal with all of that because it is not possible to force, for example, theatre owners or lecture hall owners to agree to accommodate particular strands of opinion. It's not possible to force the editors or proprietors of journals to give a platform to people whose opinions are objected to by some well-organized and noisy sector of the public. So there is the legal aspect and what one might call the popular aspect. The latter is a much more serious threat and has been ever since John Stuart Mill in the 1860s pointed out that in a democracy, the main pressure to conform would not come from governments, but would come from our fellow citizens. Now, dealing with Mr. Vance's example, the safe zones around abortion clinics seems to me to be a perfectly acceptable limitation of the right of people to say what they think, because they're not prevented from saying it everywhere. What they are prevented from doing is saying it right outside abortion clinics, thus causing harassment and distress to women who have decided it must be a very agonizing decision for any woman to have an abortion, increasing the emotional pressure on them by the kind of behavior that Mr. Vance thinks should be protected right outside the door of an abortion clinic seems to me to be it's an abuse of right of free speech. You can make your views known about abortion in all sorts of ways that don't involve harassing very distressed women. And I can see no problem about that at all.
Does that apply to people who are not exercising free speech, but are standing silently?
Well, I don't know about the circumstances of that particular case, but the law is perfectly clear. What the law says is that you can't harass people. And if you are, I mean, it may well depend on how you're doing it. If you're standing there with a whole load of posters against abortion and silently praying, it may be one thing. If you are simply standing there looking like anybody in a bus queue but happen to be praying, that may be another. One needs to look rather precisely at the circumstances. But Mr. Vance appears to be objecting to the whole notion of safe zones around abortion clinics. Now, I know that abortion is a hot subject in the United States, partly because it was an issue, until recently, a constitutional right created by judges rather than by legislatures. But we do not have that problem here. On the whole, abortion is uncontroversial in European countries where it was adopted by democratic legislatures, and the issue was dead apart from a few fanatics.
JD Vance went on, though, to quote another instance, particularly in Scotland, with taking this situation a step further, where he said a leaflet was written by the government, which was distributed to houses in the local areas, which said that even if they were silently praying within their own homes,
No, it didn't say that.
200 meters of an abortion clinic, that would constitute an offence.
No, it didn't say that, with respect.
Ah, okay.
I've read this circular, and what it says is that harassment may be committed from within a house, and that is clearly right. If you were silently praying within a house, you would not be harassing anybody, and neither the circular nor the law suggests otherwise. If, on the other hand, with the window open, you had a large prayer meeting at which the message was being boomed out to an abortion clinic across the road, that would be a different matter.
Okay. In terms of freedom of speech in this country, do you see it as under threat?
I think it is under threat, but it's not under threat from governments or from the law. Remember that there have been landmark decisions of the courts in which people who have lost their job because they entertained and indeed expressed opinions that were virulently disagreed with by their colleagues have won their cases at law. Meyer Fortstatter's case was a really important decision of the Court of Appeal. In the last couple of days, there have been reports of another case in which a Christian at a Church of England school who privately within her own WhatsApp group of friends expressed views which objected to trans ideology, was sacked from her job and has now been vindicated by the courts. That is the law in this country. Moreover, the statutes which deal with such things as hate speech contain very comprehensive exceptions for a wide range of activities, mockery, rational argument, and so on, which ensure that people are not, in fact, harassed by the law for expressing opinions that are unwelcome to other people. Now, it is fair to say that the police do not appear to be very good lawyers or to be informed by very good lawyers, because there have been a number of incidents, for example, like the rather aggressive visit of the police to a Telegraph journalist called Alison Pearson, which indicates that the police are going over the top. And I think that the police need some very comprehensive lessons in what the law is, what the limits of their power are, and how they should operate in a society where people have a multiplicity of views, all of which are entitled to be heard. But the law is perfectly clear, and I don't think that the public sphere, apart from the police, has anything to apologize for. But certainly, I suggest that Mr. Vance's complaints about the state of free speech in the UK are ridiculous and ill-informed, and his parallel suggestion that democracy is in retreat are not much better. There are challenges to both free speech and democracy. Indeed, my book is largely about them. But I think that these are complicated issues which are not assisted by ill-informed rants from the likes of the Vice President of the United States. Now, there are things that are a lot closer to the bone in some foreign countries. Notably, for example, there have been incidents in which seminars and perfectly measured occasion colloquies and so on have been organized, which have been suppressed. There was one in Belgium involving an organization of right-wing conservatives from the UK, in which the mayor of Brussels ordered the police to close it down, but within 24 hours, he was put back in his place by the Belgian Council of State, which is the Supreme Administrative Tribunal, which intervened on its own initiative to stop that. There was a much more unfortunate occasion when people who were supporting of the Palestinian position in Gaza were prevented from having a conference in Germany. I mean, Germany has a number of sensitivities about anything that smacks of anti-Semitism. I don't think that this occasion smacked of anti-Semitism, but clearly the ordering the police to close it down, and there was no reversal of that by a superior court, was an infringement of free speech, and I wouldn't for one moment defend it. But I think that to take one or two examples from different countries and to turn that into a general retreat from free speech and democracy is a little ridiculous.
Okay. What about does it concern you that an MP in Parliament has requested that we consider seriously introducing a blasphemy law? And maybe the present government tighten up its definition of Islamophobia to bring certain comments within a restricted orbit?
It would disturb me if it became law, but I would want to look very carefully at the language with which that was done.
Right. What about the balancing of these rights then between religious groups and should it be illegal in this country to burn a copy of the Quran?
No, it should not.
Not even as an aggravated offence under the Public Order Act?
Well, that depends on the circumstances. I think that, I mean, even in the United States, but certainly here, the limit of free speech has for centuries been, this is a common law position as well as a statutory one, the limit on free speech has always been drawn at the point where you are inciting people to imminent violence. So that if you burn the Quran at a public meeting attended by a crowd in which there is a significant number of Muslims, I wouldn't for a moment defend that. And the current law would mean that you could perfectly well land up before the courts. That seems to me to be a perfectly proper compromise. The concern and the limitations in English law on the right of free speech, which is a common law right that dates back to the middle of the 18th century. The limitations on that have almost invariably been directed to sensitivities about public order, which seem to me to be perfectly legitimate.
Today, particularly with hate speech laws or hate crime laws, we have a significant shift towards subjective criteria, whereby a crime is committed or a hate incident occurs if a person perceives it or a third party perceives it to be discriminatory. What do you think of that shift? Is that significant to you?
Sorry?
What do you think of that shift from objective criteria to subjective criteria?
Yes, I'm coming to that. But I mean, hate speech is normally an aggravating factor in something that is a crime for other reasons. But you are right to point out that not so much in the law, but in the police guidelines, there is a wholly subjective element. In particular, the Metropolitan Police has a definition of hate speech, which says anything that's perceived by the target or victim of the speech is to be regarded as hate speech. That is not only, in my view, a completely unacceptable interpretation of the law by the police, but it is unfortunately one which has been copied elsewhere. I delivered one of the lectures, which is reproduced in my book, in New Zealand. And so I took the trouble to look up the equivalent provisions in the law of New Zealand and in the police guidelines. And the position was exactly the same as it was in the UK. The law does not adopt a subjective view, but the police guidelines do. Indeed, the New Zealand police guidelines had been copied by the Metropolitan Police. I think that that is unacceptable. And I think that the problem about the whole concept of hate speech is that it is not possible to define it. It has very loose boundaries, and I do not think that any rule which has significant legal consequences for citizens should exist, which is incapable of proper definition, because the result of that is that you end up with the police and, worse of all, even the courts starting to make things up as they go along. The courts have been very good at resisting that in the UK. The police have not.
Right. We're coming to the end of our time together. I just wanted to ask you one last question, if I may, and it's a more of a personal question in the sense of if you were to survey your rather illustrious career, looking back on all the years that you've been doing various different things as historian, academic, jurist, what are you most proud of when you look back at what you've done?
I'm most proud of my 5-volume history of the 100 Years' War.
I thought you'd say that.
Well, you were right.
Well, I mean, it's a magnum opus. It must have been a great feeling of completion when it was done.
Yes, but it left me looking at a great hole in my life.
I I knew that would be the case too. So what is your next project then?
I'm writing a history of the French Wars of Religion in the late 16th century, the last occasion in Europe when Europeans slaughtered each other on a large scale for purely religious reasons until our own day.
Jonathan Sumption, thank you very much for your time and a fascinating conversation. The latest book is Jonathan Sumption, Challenges of Democracy and the Rule of Law. It's available at least on Amazon and probably in all good bookshops everywhere else as well. Thank you very much.